Welcome back. Aretha Franklin, the Queen of Soul, died on August 16th at the age of 76. She did not leave a will detailing her wishes for her assets. What happens next to Miss Franklin's estate, and what can we learn from it? Certified financial planner Paul Fain joins us again to take a look at your Sunday money. Paul, thank you so much for being here today.
Good to see you. Good to see you. This seems to be a not too uncommon headline where a famous wealthy celebrity is dying without much of an estate plan. So Aretha Franklin passed without a will. That's called dying intestate. Her estate's estimated at $80 million. Oof. She was divorced at the time of her death, but had four sons that will have petitioned to inherit her estate.
Gotcha. Okay. So $80 million, that's something to me that they're going to have to, I guess, divide in some way. But how does that work?
Exactly. Well, she was a resident of the state of Michigan. So the state of Michigan's estate laws take effect. So the probate court, will appoint an administrator for her estate. Her four sons should at face value be equal heirs of her estate. And the process now is in the court system, so it's a public record. And
what about some of the taxes involved with this? Because I know there's some money probably that the government's going to pull.
Right, exactly. Yeah, this could be a little sobering. You know, the current estate exemption, the federal estate exemption, is $11.2 million per person, so that's over $22 million per couple. So Ms. Franklin's estate's got basically $11 million exemption, but do the math. If $80 million estate, less than $11 million, up to $69 million is taxable, and the top federal estate tax rate's 40%, which, if you're doing the math, that's between $25 and $30 million that perhaps unnecessarily is going to go to Uncle Sam.
Interesting stuff. And so for us average folks here about our estate planning, I don't have $80 million. So what are some tips there for estate planning for us?
Well, first of all, half of Americans, Sean, to your point, do not have a will. So when you create a will or a trust, I should add, you know, you're naming an administrator, someone that you want to administer your estate. You're possibly moving it from public to the private domain. You're naming your heirs and beneficiaries. I mean, you may have 4 children. You may or may not want them to inherit equally. You can name that in a will or a trust. You know, it can expedite the process, you know, in terms of resolution, and it can really cut down on family strife. So, like you were saying during the intro a minute ago, you know, Aretha said, "You better think." So
you better think.
You better think about your estate planning. It's not that complicated. People dread it. That's why half people haven't created a will.
Absolutely. Well, Paul, thank you so much. Really appreciate it. Some good tips for estate planning. You definitely want to get with a lawyer and put those wheels in motion.
Absolutely.
That's
Absolutely
really the biggest thing.
Yep, you bet.
All right.